Hi, I'm attorney Alicia Morgan, immigration lawyer in Miami, Florida. Works for Immigration Lawyers USA. We help solve immigration problems in Miami and all over the United States and all over the world. I want to talk to you guys about some of the latest immigration news. The first is that there's a trick that's going on at immigration court, specifically affecting those who go without a lawyer to court. It's also affecting people who have been here less than 2 years inside the United States, and also asylum seekers. Those seem to be the primary targets, but it's also been against people who, even those who have a lawyer, if they were unsuspecting of what the government is trying to pull. Now here's the trick. The trial attorney, the government attorney, right, is asking the judge and also the other counsel, if there is a lawyer, but usually there's not a lawyer in these situations, they're asking the client, do you mind if we close out your immigration case? We would like to dismiss the proceedings against you because we no longer are interested in deporting you. And it's a trick. It's a lie, because what happens is, as soon as the person agrees, they think, oh wow, I won the lottery, now I'm not in immigration court, now I'm going to be out free. I'll be like a person who can apply for asylum with USCIS. So I've even heard of accounts that lawyers were saying that the trial attorney told their client in front of them, hey, and a judge even confirmed, hey, now you're going to have a chance to file your USCIS case, your asylum case in front of USCIS again. You're going to get a second bite at the apple. But it's a trick. What happens is, after they agree to close the case, as soon as they agree to close the case, the 240, this is INA section 240 proceedings, which gives them a right to due process, that case is completely closed out, and now these individuals are being detained at their court hearings. As soon as they get outside the courthouse, they're detained by ICE. Okay, and now, because they're no longer in section 240 proceedings, which guarantees due process, a final court hearing, a chance to tell your story about asylum or about an adjustment or whatever it is that you have a defense to deportation, where there's due process of law, which is guaranteed to all individuals inside the United States, no matter your immigration status. Those people no longer have that protection. Now they are placed in expedited removal proceedings. Now this is specifically going against the people who have been here less than 2 years, although I've heard of cases that they're putting people who are not even eligible, should not be placed in expedited removal proceedings, like asylum seekers who have been here a little bit longer than 2 years, if they don't have an exact date on when they came in. So there's a couple of pointers that I want to give you guys about this trend. Is that first, you should always bring a lawyer to your court hearings, especially even master hearings. It's not your final court hearing. You may be tempted to think, oh, I can ask for time, the judge can give me more time, which used to be happening, and that used to be a trend, was that the judge was going to give you more time to find a lawyer. Not so much anymore. I've seen even detained cases that the judge just says, okay, you had your one chance to get a lawyer, you didn't do it, so they schedule them for an individual hearing. Other things that can happen are that the government attorney will pull these kind of tricks and say, hey, now we want to release you, and what they do is they switch it to expedited removal proceedings. The danger, thank you, Mel, of expedited removal proceedings is that you don't have a chance to fight the case. You don't have a chance to get a lawyer. You don't have time to build your defense. Instead, they can deport you without a hearing, without a chance to defend yourself at all. They can basically just put you on a plane without any sort of remedy. It's actually crazy. So what you should do definitely is get proof. If you have been here over 2 years, bring that sort of proof to your hearing. Also contest, deny the request for the judge or the trial attorney to close your case. Just to let you know, this administration isn't closing immigration cases. So if they tell you and you're tempted to think, hey, the government's being nice to me, they understand, maybe you're even married to a U.S. citizen, maybe they understand the facts of your case, you may be tempted to say, hey, the government's doing me a favor. They're not. This administration isn't closing immigration case. They're just not. So very far and few between. A few cases out of thousands may be closed. But I would tell you, even if they offer you that, don't take it. Instead, ask to get a lawyer. Go get your lawyer, and your lawyer can negotiate with the attorney and also give you advice on whether you should consider such an option. Because I've heard of even lawyers being tricked into accepting this deal, and then the client gets detained right as soon as they leave. So if that does happen, you can do it. You can have your lawyer file a motion to reopen. But if you were on your own and you took that agreement and now you're just placed in removal proceedings, expedited removal, you're in a lot of trouble. Okay.